All right, let's start the meeting. First of all, election of chairman. Nominate Mr. Charles Walk. Second. All right, I accept the nomination. I accept the post. That's it then. Any need to have a vice chair? No need. All right. Let's invite the administration in and the representatives from Hong Kong Institute of Certified Public Accountants.
All
right, please take a seat. With us today from the administration is Principal Assistant Secretary for Financial Services and the Treasury, Mr. Maurice Liu, and from the Institute of Certified Public Accountants, Mr. Raphael Ding, Chief Executive and Registrar, Mr. Johnny Chen, General Counsel, and Ms. Linda Beck, Director of Compliance, as well as Ms. Tracy Wong, Director of Admission, and Ms. Jessie Ng, Deputy Director of Compliance. Thank you for coming. I will first invite Mr. Kenneth Leung to brief us on the bill. Thank you, Chairman. The bill actually was introduced by Mr. Chen Maobo, who is my predecessor in the LegCo. There are three main parts to this bill. Because of amendments in other ordinance, that's why this bill has been introduced. The three main areas, as I said, first is to seek to amend PAO to permit a sole certified public accountant practicing to incorporate a company with only one shareholder and to register the company as a corporate practice before the amendment of the company's ordinance. There should at least be 2 directors or shareholders to a company. However, after the amendment of the CO, it is permissible. A company can be incorporated with a single director. That's why the amendment to the PAO is to make it align with the new CO. So that a company can be set up with only one shareholder. Apart from this one, Section 7 is about the transitional period. Now, for shareholder who is not a CPA practicing, we have to make provision so that this company can also be a corporate practice. The second proposed amendment is to prohibit the use of certain misleading descriptions. Now, some corporate practices, not registered with the PAO are using some misleading descriptions. We want to stop that. The descriptions include certified public accountant in the English version and the initials PPA in capital letters, or the characters 会计师 in Chinese versions. Now, under the existing ordinance, these descriptions are not covered. That's why we take this opportunity to include these descriptions in the new PAO, so that except for corporate practices, the other companies cannot make use of such descriptions in their names. The third amendment is to make related technical and drafting amendments. This is advised by the legal section. Now, there are words like shall not be in a PAO, and we propose to use must not. The HKSAR encourages simplification in terms of law drafting, and that's why we are proposing these technical amendments. Chairman, that's all for my introduction. Thank you. Thank you. Representative from the Institute, would you like to make any comments? Or the administration, any comments, supplement? I'd like to say a few things. Mr. Leung gave us a very comprehensive view of the bill, and I want to briefly talk about the administration stance. A corporate practice can be incorporated by a CPA practicing. There was an amendment in 2003 to the CO, so that a company can be set up with just one director or shareholder. And this present amendment is to make the PAO in line with the amendment of CO in 2003. We agree with that. And the other amendment is basically to cover the use of descriptions. We support banning people who do not have who are not properly registered to make use of the descriptions, so that they will not mislead the public. At present, the PAO already have some certain provisions in this regard, so we support this amendment. The Institute, any supplement from you? No? Members, any questions? No. Very clear. Well, I have one. I can see that all along there has not been any public consultation. Well, I want to know the consultation with the members of the Institute. What are the views of the members? And what possible implication will that be to the public if the amendments are passed? And shall we further try to gauge public view? Chairman, the proposed amendments started several years ago, but last year we were not able to pass the bill. For any amendments, proposed amendments, of course, we consult our members. We have to tidy up certain wordings, and we notify our members about that. The first amendment was to respond to the amendments of CO about a company set up by a single person. Now, before the amendment of the CO, corporate practice can be set up by two directors, and only one of them, and it's fine for only one of them to be a CPA practicing. But now, under this amendment, a sole CPA practicing can be allowed to set up a corporate practice. So in this way, this accountant is a person who is also a corporate practice and can sign auditing papers. So this amendment is basically to respond to changes in the CO since 1973. Non-professionals, non-qualified professionals can't make use of descriptions of professionals. Now, under the PAO, we did not say that any CPA can't be used in the name of the companies. So now we're introducing a provision to bar people who are not qualified to use a CPA in their names. All right. Now you're saying that some companies are doing this, making use of these descriptions. Does it mean that after the introduction of the bill, they have to change the name of the companies? We already liaised with the CR and asked them that should companies apply for registration with the description in the name, then this change should be made known to them. And there are many accounting firms doing this. But for companies using CPA Limited, Certified Public Accountant, there are some in the market. But since there is no banning on such use, we asked the CR to let the companies know that they should not be doing that. All right, any further questions? If not, I would like to ask members if we need to invite stakeholders like district council, members of the public, to give their views by sending letter to them. Or is it something that's simple and we don't have to do that? May I ask the clerk to remind us something? If we are to gauge public view on the bill, how long will this message be posted on the website? Say how many weeks? If we invite written submission, written comments, that will be about 3 weeks. Well, this bill can't be submitted to the council meeting within this session. So I will not oppose to gauging views of the DCs and other stakeholders. Yes, I agree. All right, let's do it this way then. We'll invite written submission from the 18 district councils, and we'll also post message on the website asking people to give their views. Subject to receipt of any comments, we decide whether we need any further meetings. If there's no more question, we can go to the clause by clause. Any questions? Is it fine? Thank you, Chairman. May I ask the Institute to take us through the clause by clause? And Ms. Kan, our legal advisor, if there should be any technical amendments, can you remind us of that? All right. Let me take up that role.
So could the members of the Institute walk us through the bill? Would you like to speak in English or Chinese? We'll leave it to the committee. Mr. Ting, which would you prefer, Chinese or English? It doesn't matter either way. Well, I think you can adopt a bilingual approach if you like. Chairman, if I may invite our legal advisor to walk members through the bill. Chairman, I don't think I have your marked up copy. Oh, we will give you a copy. Mr. Chairman, in the marked up copy, perhaps it's more convenient for us to refer to the marked up copy. Part 2, Section 3, bracket 1, that is Section 28E. We will delete 3 and substitute that with E2 for 3 bracket 2, 28E bracket E, Romans 1, 2, 3, and 4. All the shall will be changed to must. Mr. Khan. Chairman, under 28 in English, it said the requirement pursuant to subsection 1 with the new CO, the new subsection 1 will become subsection 1 capital A. Refer to subsection 1, then I think you will need to make a corresponding amendment. I don't know whether or not the Institute had any comment on that. Mr. Le, thank you. When I received the advice from the legal advisor, I had also submitted my views to the Institute. I note that the Institute in principle has no objection to this amendment, but I'd like our legal advisor to explain this to us. That is, if the amendment to the CO is yet to be enacted, how should we amend the PAO? Which is the best way to amend the PAO so that there won't be any need for any further amendments in future? Could the legal advisor enlighten us on this? If you refer to subsection 1, under the new Companies Ordinance, once it commences, so this term will need to be amended. So we need to make the amendment before the commencement of the Companies Ordinance. I think we can refer to subsection 1, and then unless upon it commences earlier than the amendment commences with the to the PAO. So I think it would depend on which one will commence first. I think the administration's position is that the new CO will be enacted in the first quarter of next year. The legal advisor has also mentioned that under the Companies Ordinance in Schedule 10, we've included all the consequential amendments. According to Section Cap 50, there will be consequential amendments to the PAO. Our estimate for the time being is that the PAO amendment bill will probably commence before the Companies Ordinance. We hope that we will be able to complete the exercise within this year. Depending on your legal advisor's suggestion, we will take the version of the Companies Ordinance before it is amended. Schedule 10 under the new Companies Ordinance. I think in a few months' time we will be looking at what other new ordinances will commence this year, and then we'll update all the relevant consequential amendments. at which time we can make the necessary consequential amendments. I think both options will be fine. Mr. Leung, well, in that case, my personal opinion is that I think we should stick to the wordings in the bill until, I think other than the Professional Accountants Amendments Bill, you may need to make amendments to other ordinances. So I think you would submit it in whole package. I see no any obstacle or resulting in any delay in such amendments. For the sake of simplicity, I'm inclined to, depends on Ms. Quat's view, I'm inclined to stick to the existing amendment bill without any further changes. Any further views? Well, in that case, I think we'll adopt the option, that is that we will stick to the present version of the bill. Part 2, 3(3), amends Section 28D to C. We repeal 2 members and substitute that with 1 member. Subsection 4 amends Section 28D to (C), repealing subparagraph (1) and substitute that with the member must be a certified public accountant practicing. Bracket 5, under Section 28D to C bracket 2, repeal shall comply at all times with both the requirements of subparagraph 1 as regarded members. Substitute that by must comply at all times with both the requirements of subparagraph 1 as regards the member. Subsection 6, Section 28D bracket 3, repeal the word shall and substitute that by is to. Subsection 2, Section 28D4, the English text shall be replaced by must. I've also received some comments from the DFJ. We want to streamline and modernize the ordinance. I'd like to know what not is the policy of the government. That is, if we want to amend an ordinance, normally we'll also take a look at the wordings and see what not they need to be modernized or tidy up. I'd like to know what the government's policy is in this regard. I think if necessary, we can certainly ask the DFJ. Chairman, could we ask the administration give us some written explanation? I understand that you need to do the same in respect of many other ordinances. I'd like to know whether this is a policy on the part of the administration. Well, this is a relatively short bill, but sometimes you may have a bill with hundreds of sections, and we may need to, amend wordings in each and every one of the provisions. Is it the case that whenever the government amends any ordinance, it will also at the same time tidy up the wordings? Or is it that the government will have a single exercise modernizing all the words in different ordinances? Well, this obviously is not relevant to the bill in question. But we would still like the administration to explain to us what its policy is. So regarding what Mr. Chen has covered so far, any further questions? If not, you may carry on. Subsection 8, 3 bracket 8, amend Section 28D by repealing subsection bracket 5. Subsection 9, Section 28D6. I'm sorry, Mr. Chen. Ms. Khan would like to make a comment here. Regarding Section 28D, bracket 3C, Roman 2, capital A, the requirements of the company's articles, paragraph 1, shouldn't you also use the Roman letter. I think I've also raised this in my letter that is on page 2 of the marked up copy. Section 28, bracket E, subsection 3, bracket C. It said, having regards to the requirements. Shouldn't it be requirement instead of requirements? Chairman, we agree with this. I don't see any difference here. Whether there's an S or not, what is the difference? Because in subparagraph 1 there is now a single requirement. You have the same amendment in the earlier section. Well, I have no objection to that if it's consistent. Okay. So we propose that we delete the plural form and change it to requirement. Please go on, Mr. Chen. Subsection 8, Section 28D, bracket 6, repeals paragraph A and substitute that with, if a corporate practice at any time ceases to comply with any of the requirements described in subsection bracket 2 applying to it, it must within 14 days beginning on the day of the cessation notify the Council in writing of the cessation. 28D, bracket 6, repeals subsection B. 11. Section 28D, 6, bracket C, repeals C's cessor described in paragraph A, bracket 2, substituted by cessation described in paragraph A. 12. Subsection 28D, bracket 7, the word shall will be replaced by must. Bracket 13. Subsection 28D, 8, bracket B, after the semicolon, add or. 14. Section 28D, 8, bracket C, repeal the word or, semicolon or, substituted with a comma. 15. Section 28D, bracket 8, repeal paragraph D. Section 28D, bracket 9A, we propose to repeal shall as shall be thereby specified and substituted by must as specified in the direction. Section 20D, bracket 9B, C, bracket Roman 1 and Roman 2, and D, bracket Roman 1, English text. Repeal shall and substitute it with must. Section 28D, 10, bracket A and B. In the English text, repeal shall, substitute it with must. 19. Section 28D, 11A, repeal all the shall to is to, substituted by is to. Section 28D, 11B, bracket 3. In the English text, repeal shall not be and substitute that with is not. Section 4 amends Section 42, offenses and penalties. 1. Section 42, bracket 1 HA, we propose to repeal company and substitute it by body corporate. Section 42, bracket 1 HA, bracket 1, repeal person who is a certified public accountant practicing, substituted with practice unit. Section 42, 1 HA, Roman 2, repeal certified public accountants practicing, substituted with practice unit. Section 42, 1 HA, bracket 3, after public accountant, add a comma. 5. Section 42, 1 HA, bracket 3, after the semicolon, add or. Bracket 6. After section 42, 1 HA, bracket 3, add subsection 4. Includes in or uses in conjunction with its name, the description certified public accountant, the initial CPA, or the characters 會計師. In each case, other than as part of the description, initials or characters referred to in subparagraph 3 with the intention of causing or in a way which may reasonably cause a person to believe that it is a practice unit. Section 42, repeal subsection bracket 5. Part 3, Mr. Chan. Ms. Khan would like to make a comment here. Thank you, Chairman. Under 42.1 Roman 2 and 42 bracket 4a, there's the word company. With the amendment of the POAO, would you also amend it to body corporate? Chairman, we agree with that proposed amendment. We'll look at this. Any further views from the administration or Mr. Leung?
You mean change company to corporate, body corporate, to replace it with body corporate? Because that's what the proposed amendment is previously. 42.1 HA proposes this amendment. All right, I agree this proposal. All right, that's fine. Mr. Chan?
Oh, sorry.
And Part 3, amendment to professional accountants bylaws. Are amended as set out in Section 6. Bylaw 29 amended. Restrictions on names in which practice may be carried on. Bylaw 29E repeal, provided that such a name or any part thereof shall not contain or include any reference to the name of any member of such corporate practice who is not a certified public accountant. Part 4, transitional provision. Clause 7. Bracket 1. Despite the commencement of the ordinance, sections 28D and of the 28. Despite the commandments of this ordinance, sections 28D, 42.5 of the POA, principal ordinance and bylaws of the POA as in force immediately before the amendment of the date continue to have effect for a period of a year from the commencement date as regards as corporate practice in respect of which a permission has been granted by the Council before the commencement date under Section 28D, bracket 5 of the principal ordinance for the purposes of Section 28D 2C1B of the principal ordinance and to a person to whom such a permission is granted. And bracket 3 in this section, commencement date means the date to which this ordinance comes into operation, and council means Council of the Hong Kong Institute of Certified Public Accountants. So that's the amendment bill. Thank you. Mr. Leung, any supplements? No, thank you. Mr. Lu, nothing from you? So we've completed the clause by clause. And the amendments just raised will be included too. Will we raise it in the name of this Rules Committee, subject to members' agreement? Then we will put forward the amendments just proposed in the name of this Rules Committee. If there's no objection, we'll do it this way then. Any AOB? Do we have to convene another meeting? I suggest that since we may have to gather public views, we will decide whether we will have another meeting. Some proposed amendments have been raised.
circulation 我諗你最快係啦，都唔會係啦嚇。咁我哋大概都
I think so. The bills will go to the House Committee in October. That is after the summer holidays. The CSA will be circulated to members and will report the matter to the House Committee in October. All right. I think by that time, we'll know whether we need one more meeting or whether we should go straight to the House Committee. If there's no AOB, meeting adjourned. Thank you.
唔該。